respond as quickly as I can to your three comments, and then just make a very few quick points. The burden of proof issue is one that I know I have not stated very clearly in the text. It seems to me that it's a question about originalism rather than, constitutional law. I mean, the burden is on you to establish that it's unconstitutional if you go in front of a court. I think there are a lot of questions that even an originalism hawk should say are indeterminate. We just don't know. And therefore, I am a little reluctant to say that I have proved anything, because I don't want to suggest that the burden of proof is something like preponderance. I think that if you really want to say, as an originalist, I have demonstrated that the framers or the ratifiers of a given measure intended X, you have to have a lot of proof. And that's what I'm trying to say. And so I'm trying to be a little agnostic about saying whether I've proved that they thought what I think they thought, but I am trying to say the other side, has not proved that they thought what they say they thought. And as far as in practical terms, it seems to me the real concern right now is not so much an act of Congress as it is, and Judge Posner, is basically signaling this, a judicial decision saying, no, it doesn't, Wong-Kim-Ark was wrongly decided. And I think that's a subject of some concern, and so for that reason, I'm not quite as focused on the potential of an act of Congress. As far as name calling, that's an idiotic point. I don't see why I should have to know that. I will go through it carefully. Again, I do not wish to be seen as suggesting that Professors Shuck and Smith or Dean Eastman or these people are nativists. I do think that for me to call Fair and Lou Dobbs nativist is probably not a flagrant foul. But I really I do have this tendency to fling my hands about, so I'll look through that. The question about whether it's my present morality, driving my conclusion, I think I'm trying to say something slightly different, which is that after years of studying the framing of the amendment, I'm convinced it's the kind of internal morality of the amendment. That is, that the 14th Amendment wasn't just a set of provisions, it's intended to create a certain political order, and that this would be a violation of it. It does happen that I think that is the right order, but I don't think my conclusion is driven just by my personal morality. I mean, I chose to write about this issue as opposed to, let's say, the filibuster, right? I don't think the filibuster violates the 14th Amendment. I just think it really sucks. So, because when I saw this, I said, wow, that violates the 14th Amendment. We should study that. So those are my responses. I want to make a very, very few observations about why I feel nervous about originalism and why I have come up with this ludicrous description of my one-person school of thought as situationalism, because it strikes me that there are a lot of dangers of bad originalism and that those are on display in this debate. Bad originalism, to begin with, is potentially Ptolemaic in the sense that it really does view everything as somehow coming off of the energy of the framing in 1787, so that in the material about the Citizenship Clause, we get people saying that over and over. It would be very odd for the framers in 1787 to regard everyone as a citizen. Sure, it would, but who cares? They didn't pass the 14th Amendment, and it's very hard for bad originalists to absorb, that that's a different historical moment. I think the other potential danger is this seemingly rigorous desire to disaggregate the Constitution and parts of the Constitution. So let's look at the words subject to the jurisdiction, and then let's look at the word subject, and then let's look at the word jurisdiction, then let's look at juris, rather than try to construe the amendment as a whole. And what's striking about it is that in sort of Fleming terms, it actually seems to me to be more like the moral reading than like originalism, but it's someone else's morality. In other words, instead of just saying my moral reading of it is X, they say, well, clearly Locke wouldn't have liked this, and we should read it the way Locke did. The fourth problem with it is it treats the Constitution as a code, and I am always amazed at how ready my students are to believe that that's the way we should parse the Constitution, that the framers were talking in sort of Aesopian language, which they are going to learn to decode. And so the reason I think the burden of proof in this case is on the other side is simply because I think the text is pretty clear, right? I don't think it's just that hard to read this provision. See, born in the United States, check. Subject to the jurisdiction, check. Citizen, check. But then they say not so fast, and what they really meant was, and I think that is a danger that lurks in originalism. And then finally, is the point that you made, which is there's a danger of methodological sloppiness because the burden of proof is floating in the air somewhere. And there is a sense among some people that there's a determinate answer to any of these questions. I don't think there is. I think there may be one to some, but I think that we need to be fairly demanding of people who say they've come up with it. And in a lot of what passes for originalism in the courts and in general legal discourse, I don't see that. So those are the points I want to make. And I think I've underperformed my time, haven't I?